Greetings. This is attorney Della Welch, W-E-L-C-H. I am a California attorney, having practiced law for 34 years in California and in Utah. My subject today is the Anti-Slapp laws. We have that in California, and the Anti-Slapp laws stands for Strategic Lawsuit Against Public Participation. The reason for the California law is that the law wants to encourage freedom of speech in matters of public significance, and California wants to avoid chilling the speech of others. This law began originally when homeowners were speaking out, challenging and opposing certain neighborhood projects of real estate developers in court. And the homeowners won. They were often protesting, picketing, and so forth, and taking the disputes to court. Next, the real estate developers would respond with a SLAP, S-L-A-P, suit against the homeowners. The lawsuit would claim defamation and various business torts designed to punish the activist homeowners who won the initial lawsuit. The reason they wanted to punish the homeowners for exercising their constitutional right of free speech was to try and get even somehow, because the homeowners were petitioning the government for their grievances. In California, the governing law is CCP, or California Code of Civil Procedure 416, that involves a two-step process, or a two-prong process. The first prong requires the moving party to show that the matter is of public significance. So it's usually the plaintiff or the cross-defendant who wants to strike the complaint for defamation. Let us take a hypothetical example. This is just a hypothetical to help you understand the situation. Suppose Mr. A sues Company B for wage and hour violations. Then Company B files a cross-complaint against Mr. A for defamation and for some business torts, alleging that the customers were being talked bad by this particular person. Mr. A, through his counsel, then files an anti-SLAP motion. The attorney for Company B must timely file and serve a response. The response would allege that this is simply a private wage and hour dispute of an individual who didn't like the wage and hours he was paid, and would say that this matter is of no public interest or significance. In order to make a wage and hour dispute of public interest or significance, there must be facts alleged such as all workers of the city garment district are not being paid minimum wage. Well, now we're interested. It does involve public interest, and it does involve public interest, not just one little employee claiming about his wage and hour statement of no significance. Accordingly, the private person, Mr. A, in the hypothetical I gave, who was not a member of the garment district and did not have a matter of public significance, did not meet the prong 1 test to show that the litigation was a matter of public significance. Then the case ends right there. The moving party could not meet prong 1. However, if the moving party can meet prong 1, then we go to prong 2. And the cross-complainant, company B, must prove the probability that he or she would prevail in court on the cross-complaint for defamation and other business tort allegation of the cross-complaint. So the other party has a burden. The judge then considers the pleadings and the supporting documents and affidavits and makes a decision when the matter is set for hearing. There's also an important case, the case of Cotati, C-O-T-A-T-I, versus Cashman, which is 29 C-A-L 4th 69, or 124 Cal Reporter 2nd 519. This is an important case to read for a case which shows ordinary litigation of just asking for certain private relief does not rise to a public interest for anti-Slapp purposes. In other words, just because someone sues you and you countersue, that's not the constitutional interest or a public interest of public significance. If the anti-Slapp motion of the cross-defendant is successful, the cross-defendant is entitled to attorney fees under this code section. So it's very important that you prevail, otherwise in the defense, otherwise the other side will get attorney fees. This is the end of the Anti-Slapp lecture. This is not designed to give legal advice, but to discuss the topic generally.